thank you. The recording has started, so you can go ahead.
Good afternoon, everybody. My name is Patrick Oscar Matsimela, and with me today I'm with Professor Yamnek. So today's class is going to be about, it was supposed to be about the interpretation of wills and succession by contract. But today the class is going to be very short. I'm going to deal only with the interpretation of wills. Next week, Wednesday, we are going to do the pactum sesuccessiorum, that is succession by a contract, customary law, and the administration of estate. I think next week it will be our last class together. So now today's class is the interpretation of wills. Let me start by introducing the topic. As we have seen in our discussion so far, a will is a unilateral legal act which consists of the testator's declaration of intention. After the testator's death, it may become necessary to interpret his will if he has not expressed himself clearly. Now, the trouble is...
Sorry, Oscar. Sorry, can I just interrupt you? Your slide hasn't moved on to the first one. Can you
I was just introducing only.
Okay, you haven't moved on because we're only seeing the UNISA screen at this stage.
Okay, it's just the introduction. When I move on, I will tell you, Prof.
Okay, thank you. Just so we can make sure everybody sees it.
Okay. Now, the trouble is that the testator himself is not available to explain how his exact intentions were. It is then the task of the court to interpret the will in order to determine the testator's intention expressed in the words used in the will. Now, the question remains, however, whether our courts always succeed in interpreting a will in the way the testator, in fact, intended. For this reason, the testator or the person drawing up the will ought to ensure that the will is made properly and that the testator's intention is clearly apparent. Now, today, after today's class, you must be able to indicate which court has jurisdiction to interpret a will, to explain when formal interpretation of a will becomes necessary. You must explain which law must be used when interpreting a will. And also you must know the principle of interpretation of will after studying this. You must be able to indicate the golden rule when interpreting of will. You must be able to mention the principle used by the court to interpret wills. You must be able to differentiate between armchair evidence and extrinsic evidence. You must be able to write to discuss recognize the principle used in the interpretation of wills. And you must be able to rectify the rectification of the will. Thank you. Now, interpretation of wills. When to interpret a will. The court may only interpret a will, and it is not competent to alter or to change the provision of a will, except where this has been authorized by legislation. It is in fact obliged to give effect to the testator's last will as it appears from the ways which he used in the will. And now the necessity to the interpretation of a will by the court arises where there is obscurity or ambiguity in the will. For example, e.g., Thomas was domiciled in Pretoria when he made a will in 2020. But when he died, he was living in Botswana. Which law system will be relevant to interpret the will? Of course, in this case, South Africa should be used as he was staying in South Africa when he drafted the will. Now we're going to deal with the principles of interpreting a will. The chief principle or the golden rule in the interpretation of wills is that the testator's intention as it appears from the words he used in his will must be ascertained. Now, the sources of interpretation. We're going to talk about the will itself. The first step is to determine the testator's intention as it appears from the will read as a whole. The court must give the words the ordinary grammatical and everyday meaning which they had at the time of making the will. The court must attach the technical meaning to the words unless it appears from the context of the will that the testator used there in another sentence. Where words have a technical meaning as well as an ordinary meaning, they must be given in their ordinary meaning, unless it is clear from the will that the other meaning is intended. Evidence. When interpreting a will, one may always take cognizance of evidence regarding people's facts and circumstances affected by the will. And evidence fall into the following criteria. We have armchair evidence. Armchair evidence is the evidence which the court uses to place itself in the place or in the shoes in which the testator was at the time of making the will by paying attention to all the relevant facts and the circumstances which were known by the testator. And we have also what it is called extrinsic evidence. Extrinsic evidence is the evidence outside the document itself. In other words, evidence of facts which do not appear from the document itself. Rectification
Mr. Matsimela, sorry, can I ask you just to go back one slide, not the previous one, but one back? There are some students who say that they couldn't hear you. Yes, that one. And if you could just quickly repeat what you said there, because there are some students who are saying that they didn't hear you. So just repeat, please.
Yes, students, thank you. And thanks, Professor Yamnek. We are going to talk about evidence when interpreting a will. The court will look at what they use, what is called armchair evidence. And armchair evidence is the evidence which the court uses to place itself in the place in which the testator was at the time of making the will by paying attention to all the relevant facts and the circumstances which were known by the testator. We have also what we call extrinsic evidence. And extrinsic evidence is the evidence outside the document, that is the will itself. In other words, evidence of facts which do not appear from the document itself. And now we have rectification of wills. That sometimes a person can apply to the court so that the will can be rectified. And rectification takes place when the court adds or delete or change something in a will because the testator made a mistake when making a will, and the will does not reflect his intention correctly. That's why that is rectification by the court. Because one may ask himself or herself, when is rectification relevant? The court may rectify the will after the testator's death if, because of a mistake, whether on the part of the testator, the will does not correctly represent the testator's intention. Now, let's talk about the power of the court to rectify a will. Mistakes in a will can take place in the following three circumstances. Number one, clerical mistake. If for example, the 100,000 becomes 1,000 as a result of a typical error by the testator. Secondly, words or clauses that were omitted by mistake by the testator. Thirdly, words or clauses that were inserted by mistake by the testator. That is the power of the court to rectify wills. Now we're talking about presumptions. The following are the few most important presumptions. I just mentioned a few there. You can go and study other presumptions. And if you have a question, you can also write an email, or you can write a message on chats. Like I said, the following are the few most important presumptions. That is, if the testator was in possession of a will, but the will cannot be found, there is a presumption that the testator intentionally destroyed the will. Secondly, if there is a presumption that the testator did not want to inherit his children or descendants, but intended to benefit them all equally. These are only the few that I just mentioned, but there are quite a lot. Please go and read them in the book. Hence, I said, if you have a question, please, you can write us an email to that effect. And another one maybe is where the testator is not disposed of certain property or assets in his will, either expressly or tacitly, that he dies either expressly or tacitly interstate with regard to these assets. Now here's a procedure. Now we're talking about procedures now. Before or formally, when a will was interpreted by the court, the procedure was by way of an action. Subsequently, where the facts are not in dispute, the practice arose of applying for a declaration court order. The cost. Now, who's going to bear the cost? The cost of an application for rectification are usually borne by the testator, by the testator's estate. That's from the testator's estate, since the testator is to be blamed for the inadequate way in which the will was made. I think that's all for the day. Sorry for short. It's just interpretation of wills. It's too short, but you can go on further to read it. This was just merely a summary that I made so that you can try to easily understand it. Professor Yamnek.
Thank you, Mr. Matsamela. I'm going to stop the recording then now, and then we can start taking questions.